that California employers can no longer put on their application form any questions about criminal background. You can't ask it in an interview. You can't ask it in reference checks. You cannot do background checks before you make an offer of employment. And if you do want to do a background check, a criminal background check, then you have to make your offer contingent on the outcome of this. And one of the key issues is that that's going to really slow down hiring process, because you're going to have to screen everybody, figure out who you want, interviews, all of that, and then you pick your favorite person and you hire them, but it's conditioned on the background check coming back satisfactory. And that can take quite a while. The court systems everywhere, they're pretty slow at getting some of those things back. Your offer letter should reflect that if we do need to bring you on board before we get that back, if it comes back with a problem, then the offer may be void. And that is a legal thing to do. But when you do get any information back regarding someone's criminal background, you have to then take that information and make an individualized assessment as to whether or not that criminal history, that prior conviction, really has an impact on the job you want them to do. So, for example, if you have somebody who was convicted of embezzlement, that's pretty serious. I'm not happy about that in any workplace. But if the person is simply going to be doing your landscaping work outside, they're going to have absolutely no opportunity to get anywhere near anything, well, that's probably not really relevant. You're also going to look at how long ago this occurred. So there's a lot of things that are way in someone's past, may not be related to a particular job. So you're going to have to make that individualized assessment. And if after making that individualized assessment, you still believe this person should not be in your workplace, then there's a number of notice provisions. Now, technically, this law only applies to employers with 5 or more employees. Of course, if you have people in LA, San Francisco, or one of the other many municipalities that have ordinances, that number may vary. But at least on the statewide one, we have it applying only to employers with 5 or more. Now, that being said, you need to be really careful. You may want to consider still taking that out of your employment application form, even if you have under 5, because you may find yourself popping over 5 without realizing it and not remember you have to change your form, your practices, and how you do things. So if you're under 5, you can still ask about these things, but you're going to have to be extremely careful and how you manage that issue.